All right, everybody, good afternoon and welcome to today's webinar. My name is Jorge Acosta Palmer and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for Parental Rights and Education Law. Don't say gay. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded. You're going to receive a copy of the recording via email from Zoom in about 24 hours. I'll also be posting it on YouTube where you can access the recording with closed captions as well. The training was approved by the Florida Bar for one General CLE and one certification credit for education law. I'll announce the CLE code towards the end of the webinar. I will also drop the code into the chat. I will include it in the email that will go out from Zoom, and I will also include it in the YouTube description as well. I'll share a copy of the slides as well with the materials link. I've added some other materials that Dr. Brown has shared with us. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility of the captions, you can reach out to me directly. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I highly encourage you to take a look at their website. I'm going to drop the link into the chat, and I will include information about PILS in the email that goes out from Zoom. We are looking for executive council nominations, so it would be great if you have any potential nominees in mind. And with all of that said, if you have questions, you can drop them into the chat or you can use the Q&A feature. We'll try to address all the questions towards the end of the webinar to make sure that we cover all the topics. And I think that's my last housekeeping topic. So without further ado, I'd like to introduce Dr. Beverly Brown. Dr. Brown is a passionate legal advocate and lifelong educator with extensive experience in educational advocacy and Social Security appeals for children with disabilities. A former Equal Justice Works Fellow at the Three Rivers Legal Services, Beverly has represented students in due process, Section 504, and ADA matters across 17 Florida counties. She now provides pro bono services with Southern Legal Counsel. Beverly has also a rich background in teaching and program development and remains committed to empowering children through individualized advocacy. So, without further ado, it is my pleasure to pass it over to Dr. Brown. The floor is yours.
Good afternoon. It's a pleasure to be here today. Today we're going to talk about Parental Rights and Education Act, or what has been called colloquially the Don't Say Gay Act in Florida, the Florida Statute 1001.42, Section 8C3, which was passed in 2023. The overview of how we're going to proceed is to look at the history and scope of parental rights in education, the bills that were proposed before the act was passed, the actual act itself, legal implications of the act, practical implications once the act was passed, things that we need to consider going forward, and then hopefully we'll have some time to address questions. In fact, I think we definitely will. So moving forward into the history and scope of the act, I want to address parental educational rights and the constitutional provision in the federal constitution of parental educational rights and our state constitution. So if you look at our federal constitution, it doesn't specifically enumerate parental educational rights, but it has been considered one of the unalienable rights. It's not an express right. It's a right that parents have through the 14th Amendment with equal protection and through the liberty right, which is an inalienable right. And the cases that are cited that provide that right are Brown and Park and Flyer v. Doe, Wisconsin v. Yoder, Pierce v. Society of Sisters. And we'll talk about those very briefly. And then in Florida, it enumerates in the state constitution the right of parents to educate their children and provide a quality education for their children. And Article 9, which provides this right. So moving first to Brown versus Board of Education, which all of you are familiar with. In Brown, it was considered a violation of the Equal Protection Clause when students weren't educated together. Students of different races were segregated. So the Equal Protection Clause of the 14th Amendment provided that education needed to happen together. Education was considered perhaps the most important function of the state and local governments and must be made available on equal terms. And so to separate this was depriving the plaintiffs of equal protection. So equal protection through the 14th Amendment was necessary for individuals to be educated together and not segregated in the public school system. In 1925, Pierce v. Society of Sisters, in Oregon, there was a Compulsory Education Act, which required parents and guardians to send children ages 8 through 16 to public schools. Next slide, please, Jorge. And if they failed to send their children to public schools, this was considered a misdemeanor. So some parents said, you know, we don't want to send our children to public schools, and this was challenged as unconstitutional. And it was decided that the Supreme Court held that the act was definitely unconstitutional, that the parents had a liberty interest, parents and guardians, to direct the upbringing, this is the key language, and education of children under their control. And to abridge these constitutional rights was something that the state didn't have the right to do. So the Supreme Court concluded that the act was arbitrary, unreasonable, and unconstitutional. And then in 72, Wisconsin v. Yoder was decided under similar circumstances. So parents had a constitutional right to direct the religious upbringing of their children. They could, requiring students to go to public school was again found to be unconstitutional in the state of Wisconsin. And then the last case, I believe it's the last, nope, there are two more. In Park v. Commonwealth of Pennsylvania, this case considered the education of individuals who have intellectual disabilities. At the time, it's referred to as mental retardation, providing free public education for students who have intellectual disabilities. And this case determined that it was necessary to provide access to education for all of the students who have intellectual disabilities. And this case became the basis for the Education for All Handicapped Children's Act, Public Law 94-142 in 1975. And then finally, Plyer v. Doe, which is a challenge to a Texas law in 1975 that allowed the state to withhold from local school districts funds for educating students who were children of undocumented citizens, or as it's referred to here, as illegal aliens. So in this case, it was determined that it violated the Equal Protection Clause of the 14th Amendment to not provide these children who were citizens of the United States, people in the ordinary sense of the word, with an education in public education in their state. So the Texas law was overturned. So parents have had great right to control the education of their children from a federal standpoint. Then in Florida, the Constitution in Florida addresses education specifically, and this is how it's stated. The Florida Constitution in Article 9 outlines public education as the education of children, which is fundamental to the value of the people of the state of Florida. It is therefore a paramount duty of the state to make adequate provision for the education of all children residing within its borders. Adequate provision shall be made by law for a uniform, efficient, safe, secure, and high-quality system of free public schools that allow students to obtain a high-quality education and for the establishment, maintenance, and operation of institutions of higher learning and other public education programs that the needs of the people may require. So Florida takes their duty to educate everyone in the state seriously, according to the Florida Constitution. And parents in Florida have the right to access education from a constitutional perspective, federally and within the state. Moving on. This cartoon indicates our current governor as calling him Ponce DeSantis, as if he were Ponce de Leon, and he's discovering the fountain of hate, and it's referencing this particular Parental Rights Act, or the Don't Say Gay Act, with all of these rules now about no trans athletes, no factual history, no teaching about racism, sexism, etc. It seemed as if we were making some headway with equality for individuals in Florida who were LGBTQIA and youth, and this act kind of confused things for sure. And a lot of cartoonists, and I've put several in here, have had a good time parodying the situation. So in 2022, House Bill 1557 was put on the floor, and it doesn't seem like it changes a lot of things, but what it does is it confused a lot of things. It required that students' parents be notified of specific information, and it reinforced fundamental rights of parents to make decisions regarding the upbringing and control of their children, prohibiting school districts from adopting procedures or student support forms that prohibit school district personnel from notifying parents about specified information or that encourage students to withhold from parents such information, prohibiting school district personnel from discouraging or prohibiting parental notification and involvement in critical decisions affecting students' mental, emotional, or physical well-being, prohibiting classroom discussion about sexual orientation or gender identity in certain grade levels, and requiring school districts to notify parents of health care services. It authorizes parents to bring action against school districts to obtain declaratory judgments, provides for additional award of injunctive relief, damages, reasonable attorney's fees, and court costs for parents who are bringing these actions. And I have indicated, or Jorge has uploaded a settlement once this bill has passed. So the bill indeed passed, and the bill, there have been several cases that have litigated against the act once it was signed into law, and the settlement terms are as such. You can actually read the settlement, which was uploaded in the materials for the class for this presentation. But the basic terms in the settlement are this: the law doesn't prohibit references to LGBTQIA individuals, families, or issues in literature, classroom discussions, or student academic work. Teachers and students can discuss their own LGBTQ status and families. And similar to the background well, not this slide, another slide, which I'll point out. Safe space stickers are allowed in classrooms, and student-run organizations such as gay straight alliances are permissible. So there was much confusion when the bill came out, and schools got ahead of it and started acting by removing books, by not teaching certain things because they were fearful. And as a result of some litigation that has occurred, the settlement terms really haven't changed things very greatly in the current system. Okay, another cartoon. This is Mickey Mouse, and it has a sticker which says gay over Mickey Mouse's face, his mouth area. Initially, Disney was silent about the Don't Say Gay Act, but then urged by employees, they were critical about the bill, and DeSantis and Disney got into a kerfuffle over it, and DeSantis threatened Disney's tax status, and then DeSantis realized that wasn't a good idea because the surrounding counties would have to pick up that tax liability, and Disney sued DeSantis for retaliatory efforts, and since that time there has been a settlement, but not much has changed because the settlement occurred after the settlement in the actual act itself. Okay, so looking at the act, the powers and duties of the district school board. In the Parent Rights Act are such. Under student welfare, change in the student's services or monitoring related to the student's mental, emotional, or physical health or well-being, and school's ability to provide a safe and supportive learning environment for the student the parents have to be notified before that can occur. Procedures must reinforce the fundamental right of parents to make decisions regarding the upbringing and control of their children by requiring the school district personnel to encourage a student to discuss issues relating to his or her well-being with his or her parent, or to facilitate discussion of the issue with the parent. The procedures may not prohibit parents from accessing any of their students' education and health records. So if you think about it, parents already have rights to the child's educational records. Parents are encouraged to participate in their child's education. If something is going on at school having to do with students' mental, emotional, or physical health and well-being, parents are supposed to be informed and need to give consent. A lot of this seems a bit over the top, but moving on. Okay, a school district may not adopt procedures or student support forms that prohibit school district personnel from notifying a parent about his or her student's mental, emotional, or physical health or well-being, or change in related services or monitoring, or that encourage or have the effect of encouraging a student to withhold information from a parent. And the school district personnel may not discourage or prohibit parental notification of and involvement in critical decisions affecting the student's mental, emotional, or physical health or well-being. It doesn't prohibit a school district from adopting procedures that prohibit school personnel to withhold such information from a parent if a reasonably prudent person would believe that disclosure would result in abuse, abandonment, or neglect. That's quite a bit to unpack. It's paragraph 2 is telling you that the school cannot withhold information from a parent about the child's mental, emotional, physical health or well-being. that they can't encourage a student to withhold that information. But yet, if the student's going to be abused, abandoned, or neglected when they provide that information, then they can withhold that information. So that's kind of a scary position for school personnel to be in, but that seems to be where they currently are. So what was the concern? That this provision would require school districts to out students. These are the practical concerns. So out students, letting parents know that students are presenting as one gender at school and another at home. And there might be reasons for this if the family is not accepting of the student's chosen gender presentation. If a reasonable, prudent person thought doing so would result in abuse, abandonment, or neglect, the school employee can choose not to out the student. That's a large responsibility to place on someone in the school. But teachers and school staff are in those positions all the time. So I imagine it's not very different from what they've experienced. The law itself is vague, but it has many passages to lawsuits. It encourages parents to litigate, and also teachers if they are seeing things that they don't feel are within the law. And we'll talk about some of the way that occurs. And there have been some settlements. And I said that there would be an image of a safe sticker, safe area sticker. This is what they look like, this particular image here. So initially, classroom instruction by school personnel or third parties on any kind of sexual orientation or gender identity wasn't supposed to occur in kindergarten through grade 3 or in a manner that was not age appropriate or developmentally appropriate for students in accordance with state standards. And student support services training developed or provided by a school district to school district personnel must adhere to student services guidelines, standards, and frameworks established by the DOE, as it should. So initially, we're talking about kindergarten through grade 3, and dealing with sexual orientation or gender identity in kindergarten through grade 3 probably wasn't that much of an issue. But the law was expanded in 2023, or the bill was expanded to now include grades 4 through 12, and book banning became something that was popular because of this law and gender expression and the fear of certain messages in certain books. So I don't know if any of you dealt with schools during this period of time, but many of the libraries throughout Florida were without books for some time in the school libraries, and it was a fearful time for Florida public schools. On the next slide, you can see the percentage of banned books in Florida, why books are being banned. And so 48% of the banned books are violent, dealing with violence and physical abuse that includes sexual assault. 42% are banned books that cover topics of health and well-being, including mental health, bullying, suicide, substance abuse, sexual well-being, and puberty. 33% are banned that detail sexual experiences between characters. 30% of the banned books include characters of color and themes of race and racism. 30% of the banned books include representations of LGBTQ plus identities. 29% of the books banned include instances or themes of grief and death, and 6% include a transgender character. And Florida school districts are banning books that parents object to for many reasons, and these are the majority of the reasons that they're being banned currently. I don't think this is, it was new to see libraries without books, at least in my lifetime, but banning books was not something at the school level that was new to me. Frequently parents are objecting to books, and when they object, there's usually a process that is carried out by the school to examine whether the book is appropriate or not. At the beginning of the school year, each school district shall notify parents of each healthcare service offered, so this is also part of the Parent Rights Act, at their student school, and the option to withhold consent or decline any specific service. Parental consent to a healthcare service does not waive the parent's right to access his or her student's educational or health records, or to be notified about a change in his or her student services or monitoring as provided by this paragraph. So at the beginning of the school year, the Parental Rights Act requires that parents give consent for any healthcare services that might occur during the school year. And if they don't consent, they still have the right to access student records, which is a parent right. We have a couple of grouchy legislators. I think you say, remember when the word gay meant happy, fun-loving, and lighthearted, and the other one says, I hated it back then too. They did have a lot of fun with cartoons in this particular act. Before any student has any kind of well-being questionnaire or health screening form, students in kindergarten through grade 3, the school district must provide the questionnaire or health screening form to the parent and obtain permission of the parent. So forms are going home before they're provided to the children in kindergarten through grade 3 to make sure that parents approve of the forms. And then the next slide indicates that if a parent is unhappy with something that's going on at the school, there is a process for them to go through. And if a teacher is unhappy with something that's going on through the school, and I'm sorry about the wordiness of the slide, but it outlines the procedure for the parent or the teacher to go through. And I've uploaded, or Jorge has uploaded, the Florida form for a teacher to request a special magistrate. So if a concern happens, a parent is concerned, and their concern is not resolved by the school district, a parent may request the Commissioner of Education appoint a special magistrate who's a member of the Florida Bar in good standing and who has at least 5 years of experience in administrative law. And the form to request the special magistrate is actually available for you in the materials that go along with this CLE. So along with requesting the special magistrate, the State Board of Education must approve or reject the recommended decision at its next regularly scheduled meeting. And they outline the timelines for that. And so it's very precise about how parents can challenge things if they so wish. Next slide, please. If a parent wants to bring an action against the school district to obtain a declaratory judgment, the school district procedure or practice violates this, saying that the school district procedure violates this paragraph and seek injunctive relief, there can be damages awarded and attorney's fees and court costs if they receive the judgment or injunctive relief. Each school district adopts policies to notify parents of these procedures required under the subparagraph. And so it provides a means for parents to litigate if they're unhappy. And as a result, litigation is occurring. Many challenges to the actual act have been filed, and several settlements, like I said, have occurred. So that here's a teacher when it's a new mask mandate, don't say gay. When the law first was passed, it was very, very scary for many. And as it's been with us for a while, it seems kind of a vague law with numerous paths to litigate. Teachers still may be confused and somewhat scared by it because it's so litigious in nature. The next cartoon, the elephant is saying, don't say gay unless you're making fun of someone, then it's cool. I think that's more political in nature, and we won't get into that. So at the same time that this law was passed, a bill came out that introduced the pronoun law in Florida. I don't know if anyone remembers the pronoun law that was introduced, but it was about the same issue about the same time. So the pronoun law or the pronoun bill was that teachers weren't allowed to use preferred pronouns for individuals. So if an individual sex assigned at birth was female, then the teacher had to use she, her, and those kind of pronouns for that particular student, in spite of what the student wanted. And that law has been passed in Florida, but it's still being challenged in the court. So I'm not sure what the outcomes are going to be, but we have a law requiring teachers to use only pronouns that are those assigned at birth by sex, if that makes sense. So that was also around the same time. And I have not used up all of my time at all. So I hope that there's some robust discussion, but that is all I have. Do we have some questions?
Pulling up the chat just to see if we have. Yeah, we're ahead of time, but that's never bad news. So
Yeah,
if anybody has any
everybody's busy.
questions, they can use the chat. Check the Q&A. Okay. While we wait for questions, let me go ahead and pull up the materials as well, just to show where the documents that we were discussing earlier are located.
Thank you so much.
So we have the settlement agreement here. You're going to see it in PDF format. Let me zoom in a bit. So you can, that's going to be in the materials that I dropped into the chat as well. So we also have the request for appointment for the special magistrate in here.
And
And you're
that
going to
you
have a
can,
copy of the slides.
right, you can get the request for the special magistrate from the Florida Department of Education. And like I said, there's a lot of litigation still going on over all of these laws. It's confusing times. And I appreciate your participation.
All right. We do have a question, Dr. Brown, in the Q&A. I'm going to read it out loud for the benefit of the audience. The question is there any discussion or litigation on LGBTI parents who want for their student to be taught in an environment where families like there are represented, since there's a focus on parents' rights? Okay,
So
now I see the.
I'm not sure if this answers that question, but the settlement allows, in the settlement, it allows for individuals who are LGBTQ plus to share their designation, whether they are LGBTQ, and their families, and issues that their own status with students, and they can discuss that. It's not prohibiting LGBTQ individuals to discuss issues. But so is the question, are parents who are LGBTQ having any special litigation? Is that the question? Jorge, is that how you interpret the question? I'm sorry.
Yeah, I'm trying to find it here again. I'm gonna reread it. I know there was a correction afterwards, but is there any discussion or litigation on LGBTQ parents who want their student to be taught in an environment where families like there are represented?
I don't have the answer to that, but that is a wonderful question. I think there probably would be, because there is so much litigation going on, and I think that there, a little bit of research would yield an answer to that. I could find out and post, share with Jorge, and he has a list, so I could let you know. But yes, I would imagine there is. I just don't know the specific citation.
And let's see if we have any other questions. There might be another one. Let's see. Okay, so we have another question here from Dr. Kelly. Doesn't refusal to use a parent's preferred pronouns for their child somehow impact their rights under the parental rights laws?
It would seem like it definitely does. And that's why there's so much litigation going on. And I looked for results, and much of it's ongoing. So it's debating, they're still dealing with issues. I think there have been some decisions one way and some decisions maybe another way, but people are challenging the pronoun law frequently. And I can't see how that it will be able to maintain its legality. But there are lots of things that are going on that I can't quite understand, federally and within the state. So I'm not prescient, and please, understand that I don't understand everything that's happening right now.
We have another question here. Is there a resource for college students who want to learn more about their rights as LGBTQ adults?
I'm sure there is. The people that I go to when I'm looking for assistance with LGBTQ rights are in Florida Southern Legal Council, Um, they have a robust department that is always challenging, so that they're always challenging something to do with LGBTQ plus rights, and I would seek assistance from them. If I was looking for assistance in any kind of legal way, not all of the colleges, I think, are providing robust protections now, and I would certainly want to know that I had those.
I don't see any. I dropped the link for Southern Legal Counsel on their website into the chat as well. I'll include it in the email as a resource as well. And we have Kate York. She shared Equality Florida is an option too. So if anybody knows of these resources, feel free to share because I'm happy to add them into the. I have a running Google Doc in the
Me
materials. I'll
too.
drop
I
all
see
these
that,
links in
right?
there as well.
Yeah, Simone Crisp at Southern Legal Counsel would be who I would reach out to, but there probably are other resources in Florida that are robust as well, and use them, please.
I don't see any other pending questions, but keep them coming just in case you have them. I'm going to take this opportunity to share the CLE code. I'm going to drop it into the chat as well. As I said earlier, this was approved for one general CLE and one certification credit for education law. The code is 2504825N. I will also include the code in the YouTube description and the email that goes out. And if for whatever reason you miss it, just email me and I'll get it to you. The email will also include a link to the materials folder, the same one that I share in the chat. I will include some of these additional resources that we discussed into that running document in there as well. So, and since I don't see any other questions or comments into the chat, I'm going to do a quick plug for the next webinar, which is happening next Monday. This one would be on Title IX, looking backward at Educational Amendments Act of 1972. It's happening next Wednesday at noon, and I'm going to drop the registration link here just in case anybody hasn't seen it. If you just make sure to register if you haven't had a chance. So, let's see if there's anything else. All right, so I see a few. Thank you. Thank you all for joining and attending. I guess since I know we're kind of done a little bit earlier, but Dr. Brown, any closing statements before we wrap up?
I really appreciate everyone's participation, and I'm learning along with you. These laws are new to me, and it's been interesting, to say the least.
All right, well, thank you again, Dr. Brown. We'll see you everybody at the next webinar next Wednesday. Hope you all have a great 4th of July weekend, and we'll see you all next week. Have a great rest of your day.
Thank you so
Bye.
much.